Welcome to HR Innovation, your trusted source for everything HR, labor laws, and workplace trends. Have you ever wondered who is responsible for the rights and welfare of workers who are not directly hired by a company but still work for it? These are contract laborers, and protecting their rights is exactly what the Contract Labor, Regulation and Abolition Act, 1970 is all about. In this video, we'll break down, checkmark what is the Contract Labor Act? Checkmark why it was introduced, checkmark key provisions you must know, checkmark and how it impacts employers, contractors, and workers today. Whether you're an HR professional, a student, or just curious about how India regulates contract employment, this video is for you. So stay tuned till the end. We've also included a real-life case law and compliance tips to make things practical and easy. Don't forget to like, subscribe, and hit that bell icon so you never miss an update from HR Innovation. Let's start with the extent of the Act. The law extends to the entire territory of India. Yes, it's applicable nationwide, including union territories. Now, who does this Act apply to? That's covered under Section 1. It applies to every establishment where 20 or more contract workers are or were employed on any day in the preceding 12 months. It also applies to every contractor who employs 20 or more workers now or at any time in the past 12 months. However, there's an exception. The Act does not apply to establishments where the work is of a purely casual or intermittent nature. That means if the work isn't regular or is done only occasionally, the law doesn't kick in. So remember, applies across India. Covers establishments or contractors with 20 or workers. Not for casual or short-term work. In this slide, we are breaking down some important definitions from Section 2 of the Contract Labor, Regulation and Abolition Act, 1970. Let's start with the term, contract labor. A workman is considered contract labor when they are hired to do work for an establishment by or through a contractor. And here's the key point. This can happen with or without the knowledge of the principal employer. So, even if the main company didn't directly hire the worker, if the person is working for them through a contractor, they're considered contract labor. Now, let's define the term, contractor. A contractor is someone who takes on a job to deliver a specific result through contract workers, or supplies contract labor for any work of the establishment. Note, simply supplying goods or articles is not enough to be called a contractor under this law. And yes, even a subcontractor is covered under the definition of contractor. Let's quickly recap. Contract labor equals hired by or through a contractor, with or without principal employer's knowledge. Contractor equals supplies or uses labor to complete work, not just goods. Includes subcontractors too. We're covering Chapter 2 of the Contract Labor Act, 1970, which talks about advisory boards and committees. Let's keep it simple. First, let's talk about the Central Advisory Board under Section 3. It has two key members, a chairman, appointed by the central government. The Chief Labor Commissioner, Central, who is a member by default. Next is the State Advisory Board, as per Section 4. It also includes a chairman, appointed by the state government. The Labor Commissioner of the state or another officer if he is not available. Section 5 Power to constitute committees. Under Section 5, both the central and state boards have the power to form smaller committees. These committees can help the boards in specific matters like giving advice or handling particular issues. Hit like, click subscribe, and ring the bell to keep learning with HR Innovation. Next up, Chapter 3, Registration of Establishments. In this slide, we're starting Chapter 3 of the Contract Labor, Regulation and Abolition Act, 1970, and the topic is registration of establishments employing contract labor. Let's first understand Section 6, which is about the appointment of registering officers. The central or state government has the power to appoint registering officers. These officers are usually gazetted officers, that means they are official government employees with authority, and their names appear in official government records. But here's the rule, these appointments must be officially announced in the Government Gazette, that's a public government document. And lastly, each registering officer is assigned a specific area or jurisdiction, where they can perform their duties under the Act. And that's all for Section 6, easy and clear. Every principal employer of an establishment covered by this Act must apply for registration. The application must be submitted within the time limit specified by the central or state government. This is usually mentioned in a government notification. And if the employer misses the deadline, the registering officer may still accept the application, but only if a valid reason is given for the delay. Now, if the application is complete in all respects, the registering officer will approve it. Once approved, the officer will issue a certificate of registration to the principal employer. This certificate includes all the necessary details as per the rules. And that's a wrap on Section 7 Registration of Establishments. Let's look at the step-by-step process to register an establishment under the Contract Labor Act. Step 1. The principal employer must submit Form I, in triplicate, to the registering officer, along with the required fee. Step 2. The officer will acknowledge that the application has been received. Step 3. The officer will verify the application to check if everything is complete and correct. Step 4. If all is good, the officer will issue a certificate of registration in Form 2, with all the required details. Step 5. Maintain register in Form 3 of registered establishments. Step 6. If there are any changes in the establishment's details, the employer must inform the officer within 30 days. And that's the complete process, clear and simple. Like this easy guide? Subscribe to HR Innovation for more helpful videos on labor laws and HR practices. It's all about how and when an employer's registration can be cancelled or revoked. Step 1. Registration can be revoked if the employer doesn't follow the Act, fails to pay fees or fines, ignores welfare measures for contract workers, gives false information, or doesn't maintain proper records and registers. Step 2. The government sends a show cause notice, asking the employer to explain why the registration shouldn't be cancelled. Step 3. The employer is given a fair chance to respond or correct the problems mentioned in the notice. Step 4. After reviewing the response, if the government finds no proper solution, it may go ahead and cancel the registration. Step 5. Once registration is cancelled, the employer cannot hire contract labor anymore. Continued non-compliance can lead to penalties or legal action. Step 6. But all is not lost. The employer can get the registration restored by correcting all the issues and complying with the law. And that's how registration can be revoked or restored under Section 8 of the Contract Labor Act. We'll talk about Section 9 of the Contract Labor Act. What happens if an employer doesn't register? If a principal employer does not register under the Act, they cannot legally hire contract labor. They are considered non-compliant with the law. And not just that, legal action can be taken against them for violating the Act. So remember, registration is mandatory before hiring contract workers. Follow the rules, avoid the trouble. Section 10 of the Contract Labor Act, which explains when contract labor can be completely banned. The central or state government has the power to ban contract labor in certain industries, activities, or processes. The government may prohibit contract labor if workers' rights are being exploited, the work is part of a continuous process, or the job is of a perennial or long-term nature. But remember, the ban becomes official only when a notification is published in the official gazette. So, Section 10 is all about protecting workers and ensuring fair employment practices. If you found this video useful, hit like, subscribe, and stay connected with HR Innovation for more clear explanations on Indian labor laws. Chapter IV Appointment of Licensing Officers Section 11 Step 1. The central or state government appoints licensing officers. They must be gazetted officers, which means senior government officers with authority. Step 2. Licensing officers are responsible for issuing licenses to contractors, inspecting workplaces, enforcing the rules of the Act, and renewing licenses when needed. Step 3. Contractors must apply for a license, giving full details, like how many workers they will hire and what kind of work they will do. The officer checks the form, inspects the site, and if everything is okay, the license is issued. Step 4. The license may include conditions such as how many workers can be hired, their wages and working hours, and other welfare-related rules. Step 5. If a contractor doesn't get a license, they can face penalties. Also, the employer who hires them can face legal action, and their registration may be cancelled. Step 6. Licensing officers have the power to take strict action, impose fines, or cancel the contractor's license if the rules are broken. So, Section 11 helps regulate contract labor properly through a strict licensing process. Licensing of contractors. Section 12 Step 1. Applicability. This rule applies to every contractor who employs 20 or more contract laborers in any establishment where this act is applicable. Step 2. Mandatory licensing. It is compulsory for such contractors to obtain a license before hiring contract labor. Without a license, employment is considered illegal under this law. Step 3. Licensing authority. The license is issued by a licensing officer, who is appointed by the central or state government, depending on jurisdiction. Step 4. Information required. When applying, the contractor must provide the nature of work, the number of laborers employed, and the location of the work site. Step 5. Conditions of license. The license may have conditions like proper wages and working hours, welfare facilities such as canteens, restrooms, drinking water, and first aid, and other rules as prescribed by the government. Step 6. Fees and security. To get the license, the contractor must pay the prescribed fee and submit a security deposit to ensure they follow the rules. Step 7. Validity. The license is valid for 1 year. It can be renewed by applying again and paying the renewal fee. Let's recap the steps quickly. Applies to contractors with 20 or more laborers. Getting a license is mandatory. Licensing officer issues the license. Contractor must submit work details. License comes with conditions. Fees and deposit are required. License is valid for 1 year and renewable. Grant of license. Section 13. Step 1. Application filing. First, the contractor files an application for a license. This includes all required documents and payment of the prescribed fee. Step 2. Review of application. Next, the licensing officer reviews the application. They check if the contractor meets all the legal and eligibility conditions. Step 3. Issuance of license. If everything is correct, the officer issues the license. The license comes with specific conditions like worker limits, wages, and welfare facilities. Step 4. License validity. The license is usually valid for 1 year. The contractor must apply for renewal before the license expires. Let's quickly recap. File application with documents and fees. Officer reviews for compliance. License is issued with conditions. License stays valid for 1 year and needs renewal. In this slide, we'll explain Section 14 of the Contract Labor Act, 1970 in an easy way, which deals with the revocation, suspension, or amendment of a contractor's license. Step 1. Who can take action? The licensing officer, appointed by the appropriate government, has the authority to take action against a contractor's license. Step 2. Who is this applicable to? This applies to contractors who already have a license under Section 12. Step 3. What are the grounds for action? The officer can take action if the license was obtained by giving false information. The contractor has violated license conditions. There is any contravention of the act or rules. Step 4. What actions can be taken? Based on the issue, the licensing officer can revoke the license, suspend the license temporarily, forfeit the contractor's security deposit, amend or change the license terms. Step 5. Contractor's right to respond. But before taking any final action, the officer must give the contractor a chance to be heard. This is part of the principle of natural justice. Step 6. Rule-making power. The central government also has the power to make rules for how license terms can be changed or amended. Let's quickly recap Section 14. Only the licensing officer can act. Action is taken if there's fraud or rule breaking. Contractor must get a fair hearing. Actions include suspension, cancellation, or amendment of license. Central government can make detailed rules for this. Section 15. 1. Who can appeal and when? If anyone is unhappy with the order passed by the licensing officer, under Sections 7, Art. 12, or 14, they can file an appeal. This appeal must be made within 30 days to the appellate officer appointed by the government. Section 15. 2. Fair hearing. The appellate officer must give the person a reasonable opportunity to be heard before making a final decision. This ensures fairness and justice. Section 15. 3. Final decision. Once the appellate officer passes an order, it becomes final and binding. No further appeal is allowed under this act. Here's a quick recap. If you are unhappy with an order under Sections 7, Art. 12, or 14, you can appeal. Appeal must be filed within 30 days. You will get a chance to explain your case. The appellate office's decision is final. In this slide, we'll explain sections 16 to 21 of the Contract Labor Act, which focus on the welfare and wage rights of contract workers. Let's break it down in a simple way. Section 16 Canteens. If 100 or more contract laborers are regularly working in an establishment, the employer must provide a canteen. This ensures that workers get access to clean and affordable food. Section 17 Restrooms. If contract laborers need to stay at the work site, the employer must provide restrooms, clean, ventilated, and comfortable. Section 18 Other essential facilities. Employers must also ensure basic facilities like drinking water, toilets and urinals, washing areas. These are minimum dignity requirements at the workplace. Section 19 First aid facilities. Every contractor must maintain a first aid box at the work site, with all prescribed items. This is to deal with any minor injuries or emergencies. Section 20 What if contractor fails? If the contractor fails to provide these facilities, the principal employer must step in and provide them. Later, they can recover the cost from the contractor. Section 21 Wages must be paid. It is the contractor's duty to pay wages on time. But if the contractor fails, the principal employer must pay the workers and then recover the money from the contractor. Quick summary: canteens if 100 jour workers. Restrooms for overnight workers. Water, toilets, washing or first aid mandatory. Principal employer is backup if contractor fails. Wages must be paid on time. Let's understand the penalty provisions under the Contract Labor Act, sections 22, 23, and 24, in a simple and practical way. Section 22 Obstruction during inspection. If anyone obstructs an inspector during inspection or refuses to show records or registers, it is an offense. Penalty, up to 3 months of jail, or 500 rupees fine, or both. Section 23 Violation of employment conditions. This covers two main violations: employing contract labor where it has been prohibited under Section 10, principal employer not registering, or contractor not getting a license. Penalty, up to 3 months jail, or 1000 rupees fine, or both. Section 24 Other offences. This is a residual section. If any other provision of the Act, rules, or licensing terms is violated, this section applies. Example: not maintaining registers, not following welfare rules, etc. Penalty, same as Section 23, up to 3 months imprisonment or 1000 rupees fine, or both. Let's quickly recap. Section 22 Obstruction equals 500 rupees fine or 3 months jail. Section 23 Major violations equals 1000 rupees fine or 3 months jail. Section 24 Other offences equals same penalty as Section 23. Section 25 Offences by companies. If a company commits an offence under this Act, the person in charge of the business at the time is also held responsible. Even directors or managers can be punished if the offence occurred with their consent or due to their negligence. Defense available: they can avoid punishment if they prove due diligence or had no knowledge about the offence. Section 26 Cognizance of offences. A court can only take up a case under this Act if a complaint is made by the inspector, or the inspector gives prior approval for someone to file the case. Only a metropolitan magistrate or a judicial magistrate of first class is authorized to try these offences. Section 27 Limitation of prosecution. A complaint for any offence under this Act must be made within 3 months from the date the inspector becomes aware of the offence. If it's a continuing offence, the time limit is counted from the last day the offence occurred. Let's recap the key points. Section 25 Company heads can be liable for offences. Section 26 Court cases need the inspector's complaint or permission. Section 27 Complaints must be made within 3 months of knowledge of the offence. Thanks for watching. If you found this video helpful, don't forget to give it a thumbs up ka chinha, and hit that subscribe button for more HR tips, legal updates, and smart solutions. See you in the next video only on HR Innovation.